Chapter 15.1 Civil Law. Please write down all of the information on this slide. Types of civil law. Civil law. Disputes that arise when people think they have been harmed by someone else's actions. Most lawsuits fall into 4 branches of civil law: contract, property, family, and personal injury. Contract law. It is based on contracts, an agreement between 2 or more parties to exchange something of value. If one party to a contract fails to keep his or her promise, the other party can sue him or her. Property law includes rules that must be followed in buying and selling land or a building. It also covers the way property is cared for and used. Please write down the second and third bullets. Family law. This area involves matters such as birth, adoption, marriage, divorce, and death. Personal injury. Wrongful actions that cause injury to another person or damage to his or her property. These cases are called torts. Intentional tort is a deliberate act that results in harm. Negligence tort is careless or reckless behavior. Here are the steps in a civil court case. Please write down the words plaintiff and defendant and the explanation next to them. Please write down the steps in a civil court case. The legal process in civil cases. Plaintiff. The person who files a lawsuit is the plaintiff. Defendant. The person being sued is defendant. Steps in a civil case. The plaintiff's lawyers file a complaint with the court. A complaint. It is a formal statement describing the lawsuit. The court sends out a summons. It tells the defendant he or she is being sued, and it lets them know the court date. 3. The defendant's attorney files a written answer to the charges or the complaint. 4 is discovery. Before going to trial, the lawyers check facts and gather evidence by questioning the other party and possible witnesses. This is done to avoid surprises at the trial. Please write down pre-trial conference and the first 2 bullets underneath it. Please write down number 5, trial, and the explanation next to it. Please write down number 6, court gives a verdict, and the information next to it. Pretrial conference. The judge meets with both parties to help clarify differences between the sides and prepare for trial. At this stage, you both look seriously at your case, like a plea bargaining in a criminal case. Mediation. In mediation, a person acts as a neutral party to keep communication open. He doesn't decide the case, but helps the 2 sides decide an issue. Arbitration. A person acts like a judge by reviewing the case and resolving the dispute. The decision is usually binding. Either party may propose a settlement at any time. Step number 5, trial. Attorneys for the plaintiff and defendant argue cases in court. A judge or jury could hear and decide the case. Step 6, the court gives a verdict. Guilt is found by a preponderance of evidence. The defendant was more than likely responsible at 51%. Even after the verdict is given, a case might not be over. The loser has a right to appeal the case to a higher court, or if the defendant does not pay damages.